May I please your lordship? Lordship, with the consent of other side, I'd like to mention item 3 of today's daily list. Lordship, item 3. Lordship, matter may be adjourned for 3 weeks after vacation.
I think 3 is with 4 and 5.
Yes, it's the analogous method.
All will go. Next. Give some date.
But see, there are another 4 meters that may be typed with.
You give the number to the.
I'm thinking.
May it please your lordship. Well, I'm praying for adjournment item number 24. In fact, the counsel for the appellant, Mr. M. Das, is a government advocate now. I'll step in, I have to file my power, and thereafter will withdraw the application itself. In these circumstances, may I pray for adjournment for a week?
24.
24. It is infractions as on date, but since I have not filed my power, it will not be proper. Lordship.
Lordship, with the consent of the other side, I beg to mention item number 44, Lordship. In this matter, Lordship, I pray for adjournment for the day, Lordship.
Maybe I will mention item number 15, my lord. Instead of the other statement, please matter after registered, my senior HR Chaudhary is not royal, my lord.
15.
15, my lord.
The fresh matter. The fresh matter.
Yes, my lord. 1 week, my lord. 1 week of the week.
Next week.
Lordship, with the consent of other side, I beg to mention Lordship 27.
Item.
27, Lordship. Lordship, I prefer adjournment for the day, Lordship.
May I please? I beg to mention for listing, my lord, read on next week, my lord.
Why are you mentioning for? When have you filed it?
Yes, my lord.
When have you filed it?
It was numbered, my lord, 372 up to.
And then it will automatically come. Don't worry. If it doesn't come on in next week, mention it.
Well, item 9, my lord.
Give the number to the court mark. Yes, Mr. Sahav.
My lord, with consent of my senior, my lord, item 9, my lord. My lord, another one item we generated, my lord. Some notification is there, I'm told, my lord.
You have to show us which under which provision you are insisting.
Yes, my lord. Yes, my lord. So,
Next week.
16, my lord. No, okay.
16.
Yes, ma'am.
Not 16. 15.
My lord.
15.
Okay, yes, well, 15 I shall not be here, my lord.
Then 16.
16. Problem.
May I please your lordship? Lordship, I beg to mention item 23, Lordship. Matter may be adjourned for the day, Lordship. Because my senior is out of station.
Service is, report is awaited. Await service. Give some date. Next.
May it please, your lordship. I beg to mention item number 6, your lordship. Take a concern to the other side, your lordship. We have some difficulty today. Maybe after vacation, you are.
You are for Majmudar?
I am for Mr. P. Purkasta. Appellant.
Next.
May I please your lordship? I beg to mention item number 7. Wait, on and its matter may be listed after 2 weeks, your lordship.
Fourteen.
I
14.
beg to mention
14.
Lordship.
We are on 7. So 14. Next.
May I please, Lordship, I beg to mention item number 46. The attempt of mutual settlement is going on between parties. Kindly adjourn the matter.
46.
Yes, my
46.
yes, my lordship.
You have to take some instructions. You are not aware.
Attempt to resolve is going on.
Next.
May I please your lordship? With the concern of the other side, I beg to mention item number 20 of the daily list.
Item number?
20. Item number 20, lordship.
Yes.
The matter may be adjourned for the day, lordship. As I am going to file a affidavit in reply, so lordship may grant some time to file my affidavit in reply.
Next.
May it please, my lords. I beg to mention item number 47 to 50, my lord. It's fixed for hearing today. The learned additional advocate general, Mr. P. N. Goswami, would be conducting the hearing. There's some personal difficulty on his behalf today, my lord. May I pray for a short adjournment?
You are okay. Next.
I'm
May it
obliged.
please your lordship, I beg to mention item number 21. Due to personal difficulties of the engaged counsel, I pray the matter be adjourned for the day, your lordship.
15.
May
Yes,
please, Your
Mr.
Lordship.
Vikas.
With the consent of the other side, my lord, we beg to mention item 31, 32. We pray for 2 weeks' time to file the reply of the affidavit. 31 and 32. I've taken the consent, my learned friend.
Monday may be fixed, my lordship.
Because Monday, my lord, each have to come from Kachar, my lord.
You are okay. Next. At the request of Mr. S. P. Viswa. Next. Anybody else?
My lord, I have filed to writ appeal, my lord. I pray the latest Friday it may come out.
Friday, there would be some difficulty.
Monday?
Monday, yes.
Okay.
May please your lordship, I beg to mention item number 20 of daily list for adjournment for the day.
20.
Yes.
Somebody has already mentioned the matter.
Yes, my lord.
It has already been mentioned.
No, Lordship, mistakenly, I said 20, but my item is 36.
Careful while you are making a mention.
I reply for the Lordship.
You are mentioning 36.
No.
Are you for
I'm
Mr.
mentioning 20, item number 20.
20, we understand.
Mine is
30
36.
You are for Mr. Chaudhary?
You are mentioning on whose behalf?
Actually, I'm mentioning for a petitioner.
Item number
36. Yes, sir.
Otherwise, RKT Chaudhary was to take instructions in the matter.
I've taken instruction, Lordship. That's on the side. This is responsible side.
No, Mr. Chaudhary is for the central government. Anyway, if you want adjournment, take it. Next. Follow.
Item number 1 of daily list.
May I please your lordship, my lord, I may be allowed to withdraw the appeal, my lord.
Withdraw.
Yes. Obliged, my lord.
Next.
Yes, resigned.
Lordship.
Yes, resigned.
Yes,
Resign, my lord.
And you have accepted.
Resignation has not been accepted because of the pendency of the appeal, my lord. Okay.
He has joined which hospital?
My lord.
He has joined which hospital now?
Which hospital joined?
One private hospital perhaps.
Item number 2.
May it please. Lordship, on this particular matter, this matter was referred to mediation on 29/7/2022, and there was an interim arrangement between the parties. Thereafter, the matter was supposed to be taken up on 1st of November. In the meanwhile, there was some personal difficulty on the behalf of the respondent, and he could not appear before the mediator, which he duly informed. Thereafter, the next date we fixed by the mediator was 1st of December. One of his parents was in the hospital, so he could not attend 1st of December either. So therefore, the mediator has now kept the matter for 4th of January, your lordship. And in the meanwhile, the interim agreement is continuing as per the consents of both the parties, consensus.
The learned counsel appearing for the parties jointly point out that the mediation proceedings are still going on and adjourned to 30th of January 2020. Next.
30th, lordships?
Yes.
Deeply obliged.
Highly obliged.
Item number 8.
Serial number? You find out in serial number 8, other appeals are also there. We'll pass it over. Next.
Item number 10.
May it please, Lord. My lord, the appellant is the Food Corporation of India. The respondent was a contractor, a transport contractor. My lord, issue is, my lord, whether, my lord, the No, but the question is this. I heard about such action when BSNL was Post and Telegraph Department. That if you have a connection and you don't pay, if you have another connection, the another connection was disconnected. Now here the question is that whatever you have deducted is not relating to the contracting question.
That's right.
It is some other contract which, because you may be having business relations with him.
Lordship.
Now under which law or which provision of the Contract Act you can deduct it from another contract? That is the question.
That's right, my lord. But we have a particular clause in each of the contracts, my lord.
Huh.
Clause, it is a set of clause.
But
Which
counsel,
say-
that requires determination by any competent authority or the civil court. Straightway deduction. It is not like a reconciliation of a statement of account.
That's right, my lord. But my lord,
So learned single judge is correct at page 16.
but my lord, line single judge has had.
There are 20 and 21 of the judgment.
That's right. My lord, one thing line single judge has had, that after, my lord, the contract period has ended, the rights and liabilities of the parties, my lord, stands extinguished.
We may ignore that finding. We may ignore that.
Because that is contrary to section 28B.
Therefore, we ignore that finding.
Lordship. That's right.
But even if we accept that, it would be like that famous saying that operation successful and patient dead.
So, supposing, my lord, we do not have that. If if he has received some excess money, that, my lord, we can recover. Maybe.
Mr. Counsel, on the contrary, it falls within the realm of a contract.
Right.
Therefore, the conditions will govern both the parties. Now, there has to be some adjudication of the amount which you have deducted, the 21 lakhs and odd. There is no adjudication. Food Corporation of India decided itself that this is available. It is that you have acted as if it is a reconciliation of
No, my
account.
lord, what I submit before lordship is that this deduction is in relation to, my lord,
We can understand, we can, even if they have objection, we may intervene as far as 6% interest is concerned.
but the claim is not disputed, my lord.
Therefore, now you are on the right type. The actual word is claim. Now, claim, it is your, as far as FCI is concerned also, it is a claim.
Lordship.
There is no adjudication.
Lordship, right. But then this,
It is unilateral
that's right.
act on part of FCI. Therefore, we can intervene. They can be profited with 6% interest. But this amount, otherwise, what would happen? I'll tell you.
Lordship.
You would be required to file a suit for recovery as far as the second
Exactly,
contract is concerned.
exactly.
I have foreseen that attempt on part of FCI.
That's exactly right.
That is what
Lordship
you
will
want.
Lordship will then give us a liberty, my lord, to avail the other remedies, my lord, and extend the period of limitation.
So, why should he be a
because after all, it's a
law.
public money, my lord. It's a public money.
public money? Yes, therefore 6% interest and all that.
That's
These are not FDRs that
That's
people get 6% interest. It's a commercial transaction where commercial wisdom and commercial risk are two elements which go together.
Payment has been made by mistake, my lord. Overpayment has been made by mistake.
Have you recovered from your officer?
That's not, but then if that perhaps not, my lord. But my lord, even if it is by mistake, it's a public money. He is to
No, therefore, you may take all recourse available under law.
that your lordship will.
Hold. Because I have examined it from another angle also. One of your arguments which
Section 28.
no, 28 is that is okay. You take it simplicity. Now, clause 29 of the general conditions. You can still argue. I was expecting that you will argue this. That it is just like rules of business between the contractor and FCI. But still, however, those general clauses or general conditions may be similar in all the contracts. But it is attached to a particular contract and it becomes
That's-
part of the covenant of that contract.
Exactly, my lord.
It can be imported or exported to other contracts.
That's right, my lord.
That's
It is this contract which provide that you can do that. That's why, my lord. That is what I want to submit with you.
Heard Mr. Feeling aggrieved and dissatisfied by the judgment and order dated 6/12/2019 passed by learned single judge in the writ petition civil number 3261 of 2016. The respondent has preferred this intra-court appeal. Considering the players paid for in the writ petition, the learned single judge was pleased to accept the petition and pass an order directing the respondent. He was pleased to set aside the notice of recovery public deduction to the tune of rupees 21,66,907 from the respondent original petitioner and was pleased to direct the respondent, the appellant, to refund the deducted amount of rupees 21,66,907 to the respondent original petitioner with interest at the rate of 6% per annum from the date of deduction till the final payment. That too within a period of 1 month from the date of the receipt of the certified copy of the order. Or write the name of the learned counsel. The learned senior counsel appearing for the appellant has submitted that it's an admitted view from the respondent, original petitioner, and therefore, after issuance of a notice, the deduction was effective. It was also further contended by learned counsel appearing for the appellant that the observation made by learned single judge in para 20 of the impugned order is against the principles of the law of contract and more particularly section 28B thereof. On the aforesaid ground, the learned counsel appearing for the appellant submitted that the appeal requires consideration. Paragraph. For contra, learned counsel appearing for the respondent has opposed this appeal and submitted that the learned single judge has rightly allowed the petition and quashed the notice in question and has rightly directed to refund the amount of due and payable to the respondent original petitioner with interest at the rate of 6% and no interference is called for. Paragraph. Having examined the aforesaid contentions raised by learned counsels appearing for the parties, the fact remains that the deduction of rupees 21,66,907 not only relates to the other contract than the contract under which the appellants have operated clause 29 of the general conditions. The fact remains that there is no adjudication as far as the amount due and payable, if any, by the respondent original petition. Merely by issuing a notice, the same cannot be done. In view of the aforesaid, we are in total agreement with the observation made by the learned single judge in para 21 as far as the argument of section 28B is concerned. The appellant is therefore at liberty to take appropriate recourse available under law. However, paragraph, even while not entertaining the petition as the writ appeal, considering the fact that appellant is a state and ultimately any order of refund that too with interest would be at the would be a burden to the public exchequer. We deem it fit to modify the order to the extent that the appellant shall refund amount of rupees 21,66,907 to the respondent, subject to his right of adjudicate within a period of 1 month from today. And if it is paid within 1 month, the interest of order of interest shall not apply. However, if the payment is not made within a period of 1 month from today, the appellant would be obliged to also pay interest at the rate of 6% as originally provided by the learned single judge. With this observation, the appeal is disposed of. Next.
Obliged.
Matter number 11.
Majmudar was to take instructions in this matter.
The dispute was the joining dates of the appellant, the school my lord. Now I was sent a few documents. Apparently these are again copies made from the read petition and the read appeal sent by the headmaster back. They are not sending me the original. So Dr. will give me another week's time. I have called for the headmaster to attend our office personally with all the records.
Will it be possible within 1 week or we may attend it beyond vacation?
Little bit more time would be helpful, my lord, because they have to leave the school, my lord, and come with all the records.
Will it be possible? Then only we may adjourn it. If you feel that it's not possible, let it go in January.
Let it be in January, my lord.
Next.
Matter number 12.
13 and 14 all are same.
Net pleasure. But in the last occasion, learned DDC was directed to bring some instruction law.
Yes, Mr.
In fact, the query of this court on other day, whether they have held other, if not any review against this order or nothing. So, immediately we are not finding any review. Well, the fact remains that here in instant case, the appellants were research from service way back in 2008. And they approached this honorable court in 2018. Well, at the age of 55, they were discharged from service after completion of 30 years. So the finding recorded by learned single judge while passing the appeal judgment that it has become infructuous because they are not entitled for already that period is already expired.
Now you go to the original prayers in the writ petition. It's page 32 or 31 rather. Prayer 1. Why we were asking you to take instructions in the matter? This is the reason. A writ in the nature of certiorari, posting the impugn order of discharge passed by respondent number 3, compulsory retirement. Now you take a case when the petition is allowed. And it is allowed on the day on which he has attained the age of superannuation. Then the order of compulsory retirement will have to be passed if the petition is allowed, and he would be entitled to all notional benefits as if he is in service. Therefore, the learned single judge to say that it has become infructuous, that is incorrect according to us. It can be treated as infructuous. Unless and until a person, God forbid, may not be allowed, may not be alive, then also his or her heir would be entitled to notional benefit, financial benefit. How can it be said that it is infructuous? You read further, allow the petitioner to continue in service. That we understand. After 60 years, it can be done. That prayer has gone. Now, prayer 3, page 32. Directing the respondent to treat the petitioner as a regular employee of the unit. This will all have, a casting effect on his financial entitlement. It can be said that it is infructuous. It has to be considered, whether right or wrong. The learned single judge might have said that no, he is on, for example, appealing your ground
No,
that it was challenged after a delay of about 10 years.
no.
Then they can restrict the financial benefit that for 10 years you will not get.
Yes.
But it can be said that it has become infructuous. Probably learned single judge has missed first prayer and even third prayer. So we have two options. Either we admit this
No,
or we may allow these appeals and remand back the proceedings before the learned single judge for rehearing. We have two options. Therefore, we
they may not be remand back to the.
Therefore, we told
Because
you
the
that
finding is
we-
given by the learned single judge is clear that regularly they are receiving their pension till death, from the date of discharging.
Mr. Counsel,
No,
see, today their pension may be say 100 rupees.
no,
For example, if their order of compulsory retirement is converted into reinstatement and notional benefit is to be given, what would be the pension? That has to be looked into. At least technically, it can be termed as infructuous.
no.
Because if you read from paragraph 16 of the judgment,
No,
thus there is nothing in the review service to show that the reason why people are prematurely retired from service or the retention transfer, that is on merit, no doubt. On that ground, this court is of the view that the impugned orders prematurely retired do not appear to be sustainable in law. Therefore, premature retirement has gone.
no,
Then read further. With respect to the stand taken by CGC, that the writ petitions have been filed after 9 years and so and so in view of these explanations, it is possible and acceptable. So your ground is not appealed. Then 18. The above being said, a perusal of the appeal terms of 57 years age on 27, this is cross 60. The petitioners have been prematurely retired in 2008. And as they have regularly receiving pension till today, the petitions have become infructuous. This is what we object to. It
No.
can't be stated that it can be called that it has become infructuous. The learned single judge does not confirm the premature retirement order. Therefore, your order of 2008 goes.
no,
Your objection of delay of 10 years is also not accepted. So that ground has gone.
no.
Now, where is the question of infructuous? Reinstatement cannot be granted beyond 60 years. But then they have to be treated as in service from 2008, and then the pensionary benefits are to be granted.
The pensionary benefit will also do lot. Pensionary benefit will also do lot.
Huh.
Yes, sir.
Therefore, there is another way out. You can take instructions in light of what has transpired in the court today.
No,
Recalculate their pension. Ultimately, they are not going to get anything.
Well.
Only thing that we will have benefit of free disposal, otherwise nothing. And then you will be burdened with single judge, then again your appeal. This will continue.
so let's just may fix the date so that I can.
Instead of superannuation, they will have annuation somewhere. And they will not get the benefit. Next week, will you be able to take instructions?
After 10 days, no.
10 days. 19th. Let us have a chance. 19th of December. All the three matters.
Can it be on 20, Malo?
20th,
Highly obliged.
12, 13 and 14. Next.
Number 16.
But learned single judge, the impugned order has set aside a selection process in which my lord, I was not a party, my lord. I was a selected candidate, my lord. Now the writ petitioner, without participating in the selection process, my lord, filed the writ petition, my lord.
Notice. Notice.
As an interim prayer, my lord, direction has been given to hold the selection process, my lord.
Next, no interim review. Next,
Number 17.
Similar matters are being pending with this court, my lord.
I have noted that.
Yes. It's fine. I think we have annexed that also.
349.
I think we have annexed that case 206.
You can give us the numbers, Mr. Das.
The WA 349 of 2022. That's already annexed in case.
That is there. So we'll issue notice in this.
Yes, yes,
Notice to be heard along with point.
right.
Next.
Deeply. Abhi.
Number 18.
Yes, come.
May please your lordship. Lordship, upon the instructions of the client, lordship, I have the instruction to withdraw this appeal, lordship. So I
Next.
pray-
Next. Dismissal is withdrawn.
Number 19.
Subject to what your lordship may say, my lord, learned single judge did not kind of correctly apply Punjab and Haryana High Court and the Supreme Court judgment in Albad, my lord. That is a case, my lord, where 2018 rule has been challenged. Here, my lord, the petitioners were allotted
But
shop
Mr.
in the year
Mr.
2001.
Mr. Das,
Well,
ultimately you have to vacate. Ultimately, you will have to vacate. If you want some more time, we may ask the army to tell us.
that is one aspect, but another aspect in similar case, my lord, court directed, my lord, the Honorable Justice Achinta Bujaburo has passed an order to consider the matter of Greenwell.
See, the question is this. The category of entitlement as a matter of policy has been changed by the central government.
Change. Well,
As they use the terminology, the appellants are civilians.
appellants are civil.
Civilians. They have come out with a scheme that these tolls are to be given to widows of the board.
That I understand.
Therefore, the category would change. Unnecessarily asking them to, consider which is divorce their own policy would be useless.
That is true.
Instead of that, taking ground reality, you are there since 2001
Yes.
or say 2002. You also might require some.
Alternative, I'll have to set up.
Therefore, we may grant some time.
Although that, my lord, the petitioners are saying minimum 1 year time is required.
No, they-
I
We
leave
may
it to
say
your
it-
lordship.
it- In a rent tech matter, even time is granted to the tenant to vacate.
Because they will have to reallocate their shop, they will have to build the shop.
Therefore,
Takes
therefore,
time. my lord.
best thing is you file an undertaking, we will grant 6 months time. There is no difficulty. हम इनके पर विश्वास रखेंगे, विश्वास का आपके क्लाइंट है तो.
And then let it be some more, my lord. They were saying 1 year, but you lord,
1
they
year.
give 8 months or so many.
See, Mr. Das, those who
No,
are
I'm-
those who are waiting for their chance are real needy people.
My lord, my lord, practically what they do, it will be allotted in their name, they will rent it out to us only, sometime. Your lordship, I leave it to you. Lord. 6 months or 8 months, they were saying 1 year, but I think 1 year may not be good. 8 months time, your lordship may consider, I leave it to your lordship. I mean, they will have to reallocate their shops.
No, we'll find out a midway. We'll neither grant you 1 year nor anything. We'll say 31st of June 23. It will be 7 months practically.
My lord. No.
And you have to, each of them have to file undertaking within a period of 1 week.
1 week open? Oh, I'm taking the 15 days. my lord.
15 days. Disposed of. Next.
Oblige.
Item number 22.
Yes, Mr. Biswas. You have so many matters that you will not be able to sit properly.
19.
That met appeal.
Yes.
Is there any
I am parted because of that earlier case. I was very much oriented, tension. These people will be ousted from their shops in complexes. Since last 20 years, they are doing well. That's the problem. Where they will go?
They have their families, staff, matter. Well, in this case, matter, by the hand, okay, submit them.
May I please, this matter will be taken after some time, my senior is in lag, in another court. Well, time.
2 o'clock.
2 o'clock, matter. Oblige.
Much obliged.
Matter number 25.
The counsel for the appellant to take appropriate steps for service to enable him to do so. Adjourn to the date. Next.
Matter number 26.
That judgment. पीछे करते हो. Application is allowed with cost of rupees 2,000.
Hello.
Matter number 28.
May I please, your lordship? As per office note 30/11/22, ID card in respect of 8B has been received.
Item 28. You are correct. Await service. Next.
Matter number 29.
Yes.
Lordship, this is a contempt case. We had filed an affidavit in opposition. We were supposed to grant land for children's park. The allotment was passed in the SBLSC meeting and we have enclosed the minutes with our affidavit in opposition. Yesterday, they have filed an affidavit in reply.
We have not been benefited with that, but anyway, what is the reply?
The petitioner state that they want more land. They are not satisfied with the land allotted for the purpose of
It
children.
is neither here nor there. Where is it? We'll pass it over. Call for the reply at 2 o'clock. Next. Next.
Matter number 30.
The counsel for the appellant to take steps.
Please, your lordship. We have taken steps today only, my lord.
Therefore,
There may be
till
taken up-
yesterday you have not taken, therefore this order. Next. Next.
Matter number 33.
My affidavit, we are filing it today. In response to the additional affidavit, kindly give us 1 day time. Kindly take up tomorrow.
Tomorrow so
Or Friday.
Tuesday. Next.
Matter number 34.
Oh, that's the great.
Lordship, my Passover for the type it.
2 o'clock.
Next.
Next.
Matter number 35.
Meet the lordship.
What is the contempt in order?
my lord.
What is the actual contempt in this order?
Contempt is, my lord, lordship will find the judgment of the learned single judge, my lord,
Hmm.
at page 10, my lord. And relevant portion is, my lord, page 25. Paragraph 30, my lord. Respondents were directed to grant the revision of pay to the petitioner. Thereafter, my lord,
You're referring to para 30.
there are 30, my lord. There are 30. Thereafter, my lord, appeal was preferred by the state, by the union, my lord.
Turn to page 33 and read para 9.
My,
Turn to page 33 and read para 9 of the division bench judgment. We have carefully perused the judgment under appeal. We find that the facts and circumstances of the present case, the view arrived by the learned single judge is possible view permissible. We do not find any ground to come to a conclusion different from so. Then you can say, you can skip this. So what you were reading is confirmed by this division bench.
my lord.
Yes,
Confirm.
Mr.
Therefore,
Chaudhary.
SLP is filed. SLP was also dismissed.
Yes, Mr. Chaudhary.
Lordship,
Any curative petition is
Lordship,
contemplated?
my instruction was that a review was filed, but in the meantime, that a similar issue, I think my learned friend has also proven.
Hmm.
That case is coming up day after tomorrow before the Honorable Supreme Court, Lordship. So in the meantime, the MOD has been moved, Lordship. Perhaps they are waiting for the outcome of this case day after tomorrow. If it can be in the next week, Lordship, I can
Monday,
give something concrete before this.
Monday.
Right.
At the request of RKT Chaudhary, Deputy Solicitor General of India. Next.
Matter number 37.
Yes, my lord.
May it please the lordship, because matter needs to be heard because petitioner was neither a party in the writ proceeding, nor was he a party before the writ appellate proceeding.
But how
are you affected? My lord, I am affected because pursuant to the order of the writ appellate court, the DPC, my lord.
Are you promoted pursuant to the DPC?
Oh, yes, my lord. Well, that's not fair, may I? My lord, DPC was constituted. DPC gave its recommendation. Out of the chairman and the 2 members of the DPC, 2 members of the DPC signed the DPC. DPC recommended me for promotion. Before chairman could sign it, the respondent number 2 submitted a representation and followed by, my lord, the review petition was filed before the single judge. Review petition dismissed. After dismissal of the review petition, the writ appeal was filed. And my lord, what happened in the writ appeal, my lord, is known to all of us. That is how, my lord, what happened was pursuant to the order of the writ appellate court. The DPC, my lord, is not moving ahead at all. And the DPC, my lord, which was constituted. Yes.
You're not promoted.
My lord, I am not promoted, but I have been recommended for promotion.
You the entire matter before the learned single.
My lord, my lord, may I put it this way?
How are you affected?
Again, I'm explaining, my lord, how I am affected.
No.
I'm affected, my lord.
Mr. Counsel.
Read and reread. We have not understood
Mr.
how you are affected.
Mr.
I'm
Counsel,
affected
the
with-
question is to cut short your argument.
My lord, my answer is, I'm affected because the writ appellate court remanded the matter to the learned single judge to consider the aspect as to whether the 2004 rules have to be read along with the office memorandums which negate supersession in promotion. This is what the writ appellate court has done. The matter has been remanded to the single judge to rehear the writ petition itself.
Therefore, Mr. Counsel,
My lord.
we can only pass one order today itself, making you a party before the learned single judge and asking the single judge to hear all the parties and decide it within some stipulated time. Otherwise, on technical grounds, our direction is not illegal. If you feel so, you file an appeal.
My lord, that I understand, my lord. Certainly, my lord, what has fallen from my lord is correct. I admit that.
So
I
that
admit,
you-
but,
you-
my lord.
you- from what you have, from what you have stated in the application and what you are submitting before us, because of pendency of the petition, now the department has stayed their hands because there is no stay on DPC.
Yes. Yes,
There is no stay on DPC
yes, my lord.
technically,
Yes,
but they may, for a change, think that proprietary demand. It generally, it is flexible or elastic for the government.
my lord, there are two aspects.
Sometimes they wait, sometimes they don't wait. It depends upon the advice that they get.
My lord, accepting everything what has fallen from my lord, there still is, my lord, there is one rider. The difficulty is, it is not only that there is no stay on the DPC. The DPC was already constituted. The DPC gave its recommendation also. And the DPC in its recommendation, my lord, held me eligible for promotion. There was recommendation for my promotion. But, my lord, the recommendation of the DPC
That
have
we have-
not
we have-
attained the finality.
We have understood.
My lord.
Therefore, this we can provide in this order today.
Very
Go-
well.
Go to the learned single judge, we'll make you a party there. And we'll request the learned single judge to hear the fix the matter in dispose of. as
Very
early
well,
as
my lord. Agreed.
heard.
Very
Only? What is it? Heard Mr. P.K. Tiwari, learned senior counsel. He is from Supreme.
I appear for the writ appellant, respondent number 1 here.
Write the appearance by way of this review appeal, review petition. The applicant is prayed for the following reason. Paragraph. The predominant objection raised in the contention raised in this writ appeal, review petition, is to the effect that the directions issued by the Honorable Division Bench, coordinate bench of this court, with the order dated so which is under review in this application, has affected the chances of promotion of the applicant. Mr. Tiwari also further pointed out that because of the state direction, the EPC proceedings were suspended, public, not taken further. And the matter is stuck before the learned single judge, wherein the applicant is not even a party. Having heard the learned counsel appearing for the parties, and in peculiar facts and circumstances, we deem it fit to pass the following order. 1. The applicant hearing, that is review petitioner, is made a party to the writ petition number so and so. Yes. The learned single judge before whom the proceedings of writ petition are pending shall hear all the parties and fix the matter as expeditiously as possible and decide the same in accordance with law. In accordance with the directions issued earlier by this court. The review application is disposed of. Next.
Obliged. I hope there will be no further review.
There can't be any because there is no third person. Of course, there is one, Mr. Zirang, but he will not come.
So I can see in the record, there is already one review which is.
Which has been dismissed.
Yes, dismissed, but my lord, we all know very well the circumstances under which it was dismissed, and my lord was a party to that.
Mr. Tiwari,
My lord,
I can't be a party.
my lord was a party of, my lord was one of the constituent member of the bench.
Mr. Tiwari,
My lord,
now that the matter is over and the order is pronounced, I'm sure none of you will be ready before the learned single judge and it will be disposed of.
he will be ready.
No, the learned single judge also will not be required to go into the marriage.
My lord, in all likelihood, possibly yes.
I have forced in this, therefore,
my lord.
but as a judge, I could not,
My
because the
lord.
matter is over.
My lord.
All right.
In Hindi, there is a saying,
Yes.
"Chor pakar mujhe jor aata hai."
Got it, got it, got it. Yes.
Like tug of war.
Yes.
I don't know
yes,
about you. I have played many a times in my school days.
Yes.
Because the fat man is always tied at the last with the. In my childhood, I heard that. This is what I have foreseen.
But it's good that way, my lord. It will be advantageous to us.
Sometimes we as judges also, Mr. Tiwari get. Rather we get attracted to see that what can happen in this matter. As you people think when you are.
Yes, yes.
That's the human instinct. We can't
That's
control.
true, that's true.
Next.
Item number 38,
Oh, that herbal. Herbal life.
My lord, I
You,
pray for a consideration, at least, because we have argued the matter at length.
you want life in this matter?
What
January.
possibly I could see is that,
January.
lordship,
Next.
some other thing, my lord.
Some other day.
Some other time, oblige, lordship.
item number 39,
My lord, in item number 39, we have taken steps and we have filed affidavit for service of notice upon the newly
Justice service is
completed
filed.
respondent.
No, it is filed. Justice service is filed. We have seen
So,
that in the.
perhaps
Anyone appears for the
respondent, someone appeared, I think he is appearing. For respondent number,
Are you ready with the matter?
Well,
You give
Lordship-
him the paper book if he doesn't have it.
well, yes, the extra copy of memo of appeal is served along with the notice.
My lord,
May I-
request of so and so.
Fixed for admission.
My lord,
Take date of your choice.
14th.
14th
14th, next-
January is a holiday. Now it will come beyond vacation. Next.
item number 40,
Respondent 5 is not served in this matter.
My lord, item 40, my lord.
Ah.
My lord, my learned friend appears. That's why, my lord, he informed that he will appear. That's why my instruction is that they will not take it.
Because thus the affidavit is not filed.
Yes, my. That's right, but my learned friend appears, my lord. His name is also shown in the call list.
So what do we do?
My lord, let it come for admission.
Because the number itself is very dangerous, Mr. Supreme.
002, my.
Next.
My let me record my payments.
You will have to file your wakalat.
My let memorandum has been filed. That is why the
Then it will automatically be reflect. No problem. Next.
item number 41,
Yeah, okay.
May I please your lordship? Lordship, as per the direction of this court, we have filed an IA for impleadment, lordship. As the respondent one has been transferred, we have newly impleaded respondent one.
ये लाओ नहीं इनके साथ है। Mr. Nayak, would you be appearing for the
Lordship,
other officer itself?
No, I am appearing for respondent number 2, lordship.
Because here the opposite party Diganta Barawa, IPS Commissioner Secretary Home. So ultimately it is government officer.
Yes, sir.
Huh.
Possibly listen notice. He may have some his personal choice also.
What personal choice? He may not have any personal choice. Talk to him and tell us at 2:00.
In that case, lordship, I will on the next day, lordship, I will file wakalat on this day.
Therefore, you talk to him and tell us at 2:00. If he
Lordship, I can, lordship. I know him.
talk to him, 2:00.
item number 42,
42 lordship, contempt petition was closed, fixing a time frame for compliance. Since in the main order, there was no time frame,
So, but even then, even thereafter, it was not complied of. So, and there was a liberty that it was closed with the observation that the liberty to revive in case of difficulty. So, I have filed this IA so that the contempt petition may be revived, Lordship.
Now, who is the respondent here? It's Srinath.
Respondent at page 3 are there.
Concerned of advocate would be Dinath, State of Gujarat, arrest. Miss K. Pufan. You serve them the copies and come at 2 o'clock.
Okay.
Next.
So number 43.
You ask Mr. Dinath to appear.
May please your lordship, this is IA for setting
Substitution.
aside abatement of substitution.
Will pass appropriate. Allow. Next.
Much obliged.
So number 45.
My lord, the matter may pass over for the time being. I am Mazumdar is in court number 8.
Let it be adjourned. Hearing matter don't pass over. Some other day. Next.
Some other date is.
Some other day.
Vacation. Let me after vacation in that case.
After vacation.
Oblige.
Matter number 8.
Mr. Puyan,
My
other
lord, I seek apology, my lord. I was,
no, other appeals are pending
no, my lord, regarding this subject, my lord, there is no appeal is pending. my lord.
because it's a common order in more than one read petition.
No, my lord, yes, it is a common order, but this, only this appellant has come before my lordship, my lord. My lord. Lord, the issue in the appeal, my lord, is that, my lord, regarding madrasa TET examination, my lord, which had been conducted by the state of Assam for the purpose of madrasa educational institutions and appointment of teachers, my lord. And thereafter, my lord, this madrasa TET qualified candidates, some of the person has got their appointment in other categories of institutions. And my lord, therefore, this appellant wanted to participate in the other categories of institution also. But the government initially allowed and later on declined, my lord, and those impugn orders were challenged and the learned single judge has upheld the decision of the government, my lord. My lord, some hearing is required, my lord, and my respected senior friend has expressed some difficulty on his part today, my lord. My lord.
Excellent. Which date do you want? Select your date.
A week's time would, a week or two, my lord. That's what
Because virtually it is a fresh matter.
yes,
My lord.
otherwise he had appeared in the matter with the learning single judge also. The AG had
We have seen the.
he's conversant with the matter.
When do you want? Take the date of your choice. Hello, next, follow.
19th, matter,
Any date. that you-
19th. Oblige. 19th.
Oblige, my lord.
Matter number 22.
I thought I seek apology at that time I was on.
My lord, mediation was failed, my lord.
But the mediation has failed.
Yes.
Your lordship has taken in interest and sent back this matter to the Lakhimpur, my lord. But my friend client did not agree to accept any formula. That is the problem.
Then we'll admit the appeal is already admitted, isn't it?
She was provided 10,000 rupees. So
Huh?
she was provided 10,000 rupees as permanent element.
No, how it can possible?
So my lord.
10,000 cannot be a permanent. My lord, he was a LB school teacher, Hindi teacher. He retired. Now, my lord, 15 years, there is no relation, my lord. The learned district judge has rejected the divorce on the ground that there was no cruelty. But Supreme Court judgment, my lord, I am placing a judgment, filing a maintenance, this 498A and to causing suffer to the husband, it is amount to cruelty. Supreme Court has held that, my lord. That's
We'll-
the decree of divorce was
Admit
granted.
the appeal, what else can be done? Admit. So and so ways, LCRP called for. Next,
Obliged, my lord.
Matter number 29.
May I please your lordship? Lordship, affidavit in reply has been filed, lordship. And kindly taken up this matter on Monday, Lord.
Monday.
Obliged, lord.
Matter number 34.
Lordship, this matter pertains to the issuance of license for IMFL onshore. And I have raised the issue that without complying the excise rules, the excise department has taken initiative to issue license. My contention is that rule 294 is not followed.
What are your contention? We are noting down. इसमें तो अलग होंगे ना अगली मैटर से इसमें अलग होगा एरिया बदल गया तो
But
you take contentions as per the area. अभी यहाँ स्कूल और टेम्पल का नहीं है यहाँ कुछ दूसरा है.
this time, Lordship, it is a purely residential area.
That is why I am telling you, we have gone through the matter. Last time in the matter which you have already argued and we have we have pronounced the judgment, it was 294 probably.
294 is also here, Lordship.
हाँ वो तो common होगा ही. You need not argue all points because some of them are all common in your matter. Within a short period, I have come to know. Then why not? My brother is a permanent feature here. He is elevated. So tell us.
Lordship, they have filed affidavit with the excise department.
Yes.
And it is the admitted fact
Huh.
that the proposed site is in a thickly populated area, residential area, and no inquiry is conducted.
Now
Now,
GS road is thickly populated.
Yes, it is not,
GS road,
but not residential.
that is your say. आजू बाजू में तो residence है. My brother also lives very near to GS road.
Yes, yes.
I have seen a shop there while passing through. Not one.
But these people are so kind and generous enough that they never raise any question. But here the picture is
You are
different.
there. Who is this petitioner? Who is the petitioner?
Petitioner is a social activist.
No, where does he stay?
No, he is not within the 75 meter.
That is why I am saying.
But what if the
See, this is a matter where we will have to go to the root of the matter, that how is petitioner public spirit is affected.
it is affected because if such excise soap is established in
Because
this area,
he lives at Lakhipur district, Golpada.
yeah, within the nearby area.
No, nearby area means you can say that Guwahati is also 3.5 hours away from Golpada.
They are far away.
Anybody can be
Their
near.
residents are far away from that.
My brother can say that I am portfolio judge of Golpada, so I am also interested.
Since it is a PIL, Lordship, the anybody itself.
No,
So
we say, we know the limitation. You should give me some credit that PIL started from Gujarat. So it is in my genes.
Also in enquiry report also it is reflected that here residents are far away, that is more than 75 meters.
No,
from the
You can take your
proposed site.
contention so that we can deal with it.
Lordship, may I draw your attention, Lordship, on the
No, you don't draw attention, you take your content. We'll hear you at the, therefore we keep this matter at we have kept this matter at 2 o'clock.
The first issue that Lordship I need to address, that a public complaint was made. The genesis of the PIL is that when the authority did not respond positively, only then some people came forward to raise the issue before this honorable court.
That you need not say. We are not going into the reason why petition is filed. The question is, what are your contentions as a petitioner?
That only two contentions.
Then you
Rule
take,
294, there is admitted fact, they have admitted in their.
we'll go into it. Why do you say admitted so affirmatively? We'll examine in your presence. 294 not complied.
Yes.
What is your second contention?
This Lordship, some people, they are the resident within the 75-meter area. This UP Pali, who is the resident of his house, is located in the dark number 678 of the particular plot that I have annexed the trace map also.
Yes.
And the Topan Raba, dark number 680.
Yes.
Nabonita Raba 679 and the Gulam Mustafa 676. They are residing within the within 75 meters, and they have raised the complaint, but this complaint has not been addressed properly as per the rule.
Not addressed as per the rule. Okay. These are your two contents.
These are
what is your reply to it?
Lordship, kindly, my in affidavit, kindly see at para 13, Lordship. As regards the sentence made in paragraph 10 of the writ petition, complaint petition has been submitted against the proposal at some individual level. And all those petitions have been looked into while conducting the including inspection. As per inquiry report of, there is nothing adverse against the proposal. In this regard, the inquiry report of the inspector of
Where are you reading, ma'am?
Lordship, in this regard,
where are you reading?
Lordship, at page 28, Lordship.
Para number?
13, Lordship.
As regards the statements in para 10.
Yes, Lordship.
Nothing adverse.
Nothing adverse against the proposal. In this regard, the inquiry report of the inspector of excise has reflected that the complaints and the 34 others are residents of area far away, that is more than 75 meters away from the proposed site at Halwapara, ward number 4, Lakhipur. And the copies of the inquiry report, that is 26th of November 2021, is issued by the inspector of excise, and inquiry report issued by the inspector of excise dated 20 June 2020 are annexed here.
Now go to page 52 and read para 6. Go to page 52 and read para 6. Because that is his main ground according to me. 294 is no ground.
Reply
affidavit.
Page 52.
Para 6.
Para 6.
That the deponent states that the proposed wine shop shall be established in a plot of land which is covered by so and so. Then he has given the Yusuf Ali is within 75 meters. Tag number so and so is residential house of so and so. So and so. They have also made complaint to the Commissioner of Excise, but is despondent in their affidavit and remain silent.
Lordship,
You have to give reply to this.
Lordship, kindly see in annexure 4 and 5, it is in my affidavit, it is 38, Lordship. There are some complainants' name also.
No, that
they are. But
you have to tell us about this complaint which he is saying, whether those complaints have been received by you or you have not received, and he is making a case in reply.
Lordship, in writ petition, these complainants' names are there. They have made complaint, and in this inquiry report, what I have annexed here in annexure, dear residents are, can you see, Lordship,
Madam, you just please apply your mind to what we are saying. We want answer to this. What has happened to their complaint?
Yusuf Ali.
Lordship, I may be allowed to interfere on this point.
You know,
Actually, this.
Lordship, I have just received his affidavit.
yes,
On
yes, yes,
yesterday
Majmudar,
basis.
Majmudar,
On
what were you
yesterday.
saying? What were you saying?
That is the issue that they have stated in their affidavit that the one person, some person, including one Manjit Kalita, his residence is within the radius of 75 meters, but somehow he has withdrawn the complaint. But
That
he-
is, no, we are on your para 6. That reply we want.
yes, yes, I am coming Lord to this, then this complaint is,
What has happened to their complaint? Which you are saying in, because you have no personal knowledge,
yes, that is,
then on what basis you have stated all this on oath? That is what we are examining. Because that is the ground that you are raising in your argument. Yes, madam, you will have to answer
Lordship,
page
I will
52
produce the record. Kindly some time may be given
tomorrow
tomorrow.
at the request of so and so tomorrow.
May I also make a prayer, but I fear for the private respondent. Have nothing with the copy of the affidavit application as well as the.
That
I
you-
also wish to find a reply. Not
We will not permit you to file any reply.
if certain documents,
Huh.
perhaps it will be important.
Maybe then you show the documents to us. We will not attend the matter.
What has happened is there is another pawn shop right next to it. That is why it is at the behest of certain private.
We don't want to examine that. We want to be satisfied with his two contentions. He has already made his submission, 294 and this complaint. So you get the original record. It is from which place?
Gwalpara district,
Gwalpara.
Haulapara.
Lordship, it may not be possible for
Lordship,
tomorrow. He is
NOC
actually-
also given by the
tomorrow.
some people.
Why are you worried about tomorrow? Golpada can be traveled within 2.5 hours with a stopover. If we can go in the morning and come back late in the evening, why can't officers travel?
That is true.
Then why are you worried? Our officer has come from Silchar within a 1 day's notice.
Lordship.
It's not your worry. Call your officer with original file. Satisfy yourself and tell us. Chalo, call out tomorrow.
Matter number 41.
Oh, next.
Lordship, I'm appearing for item number 1.
You will be appearing for
Yes.
that. I allowed and wait by so and
It's what.
then you take instructions. We are keeping it next to Wednesday.
Lordship.
Next Wednesday. Next.
Obliged, Lordship.
Matter number 42.
Yes, Mr. Nath.
Malad, I have gone through the IE, Malad. Lordship may grant me some time, Malad. I will take the instruction from the respondent number 3.
If it is not decided, see that he decides it.
Lord.
Thursday next.
Obliged.
Next.
Matter number 51.
Mr.
May I please
Majmudar.
Lordship?
Now only I think Mr. Sakya is left out from the team of government.
Today possibly he is not present here.
It started with her, then Bora. Of course, Bora came as a night watchman, but you come as a counsel. See, I'll tell you what the crux of the matter and why your officers are called.
I've understood. I'm told that anyway.
To resolve this issue. On record of the petition, there is a notification issued under section 48(1). Mr. Bora's instructions were, and his argument was that actually we have not withdrawn from acquisition. But it was not denotified, but it was abandoned. Now, Land Acquisition Act envisages three types of denotification. One is preliminary notification is issued under 4 and it is dropped from section 6 notification. Then nothing is to be done, no damages, nothing is to be provided. Second, chances that declaration may be made, but possession is not taken. Now 48(1) would automatically come into operation once section, because section 6(3) says that declaration means it evolves to the government free from all encumbrance. Therefore, 48(1) was constituted, or rather provided in the Act. Now there is a notification under 41(8), but he says that no, it was abandoned at the stage of 4. Means it was part of preliminary notification, but it was never part of the declaration under section 6. This is what we want to know from you. Because if declaration is not there under section 6, then there was no need of, and this is not only one plot. If you see the notification under section 48(1), there are number of plots. So once the power under 48(1) is exercised, it presupposes that section 6 declaration has to be there. Please turn to page 42.
42.
Now see, it is withdrawal from acquisition. So and so, covered by notification dated so and so at page so and so. Now, once you exercise powers under section 48(1), then 48(2) and a right which is created under 48(3) would also be there.
48(2) will automatically come.
It will automatically come. He is the master. He can come to the conclusion that there is no damage.
Yeah.
Then the landowner may remedy under subsection 3 of section 48. Which is almost akin to a reference under section 18.
Old Act.
Well, the old Act. This is old Act.
Under the old Act.
Therefore, to say that it was abandoned under, but now see the reasonings given by the learned single.
Start from
Para 4 onward.
Yes.
Respond number 4, the Deputy Commissioner Chahar, Hilchar, through his so-and-so affidavit in over stated the River Army inspected the lands to notify the, however, we did their letter informed the so-and-so low lying, then it is not suitable for construction. On basis of the said letter, respond number 4, by way of subsequent notification dated so-and-so under 48(1) of the Land Acquisition Act, he acquisitions the land mentioned in the notification dated 8/4/2009, it has been specifically denied by respond number 4 that the petitioners delivered possession, nor the authority concerned took over the possession of the land from the patada. Against the said specific stand of the respond number 4 and on submission of the petitioner that the possession was delivered to the authorities, difficult to decide such a disputed question of fact. Now, by land acquisition, please pass on land acquisition. Because this is contradictory stand. Because once the possession is taken, then you can't take power, you can't exercise power under 48(1).
Basically says if possession is not taken.
That famous case of Godrej Poets. The whole classic case on this. Therefore, your conduct, once the 48(1) is exercised. Now only see why I am saying 6(3).
Yeah.
Section 6(3).
Yes, that's what I'm saying.
You must have reread all.
Well, I'm reading it again.
But we may read so that we can also rebrush our memory.
The said declaration shall be conclusive evidence that the land is needed for a public purpose or for a company, as the case may be, and after making such declaration, the appropriate government may acquire the land in a manner hereinafter appeared.
Now section 16, 1(6). When the collector has made an award under section 11, he may take possession of the land, which shall thereupon vest absolutely in government free from all encumbrance. Now, if possession is taken, 48 would not apply.
That only presupposes, my lord, an award. Possession presupposes an award.
An award.
In our case, there was no declaration.
That is what I am saying.
Well.
Now, therefore, but 48(1) will apply.
My lord, my humble submission before Lord, this possibly this 48(1) notification ought not to have been issued.
Exactly.
My lord,
I wanted Mr. Bora to tell me that.
My lord, normally this is what is, my lord.
Because see, there is a difference between abandoning the result. If you, I have seen in my career
My lord,
many declarations under section 6,
my lord.
which says that qua patta number, we have survey numbers there. Survey number, the acquisition is abandoned.
Abandoned.
Because section 4 is a preliminary notification.
That is not the final.
It's not final.
That-
If you read the words,
My lord,
thought to be acquired.
not today.
And that is why in common parlance, we may say section 4 notification, section 6 notification. But preliminary 4 is just like an invitation to offer.
Absolutely, my lord.
It is a preliminary notification. Then section 6 notification is a declaration. You see the word, every word that the
Yes.
parliament has used.
6 is declaration.
Therefore,
And
you will have to,
Before that, my lord, there will
because
be,
if it is abandoned, then 48 would not apply at all.
yes. In fact, my lord, I do not know. If the lordship permits me, I'll argue. This notification we can withdraw now.
That is what
For-
you will,
for
but
this-
what will happen to other plot? We are worried about it. You can again turn to page 42.
40.
That is why we troubled your officer to travel all
My lord,
together
my
from
lord,
Silchar.
42, I'm looking at.
Now there is only one case, Mr. Majmudar.
Right.
This notification under section 8 on dated 8th April 2009 is under 4 or 6?
I'll actually.
Under 4, Lord.
Therefore, this is abandoning the acquisition, not withdrawal.
No.
The powers have been wrongly exercised by the government.
Right.
This will entail a huge liability of the government. What worries
Yes,
me is
yes.
that one case here or there doesn't make any difference.
Absolutely.
Because you see the liability of the government under subsection 3 of 48.
My-
It's a huge thing.
Huge. And here, a number of plots, huge number of plots are
That is why.
3,000, 2,122 bihars. A huge burden. When the act and the provisions do not provide that, we should fear the burden.
Exactly.
And there is another aspect, if the lordship permit me. It is the requiring authority, that the central government, appropriate government is the central government. If at all, if any compensation is to be paid, that is to be paid by the central government, not by the state.
No, that is
Another
the
aspect,
principle of
another aspect.
acquiring body.
My lord.
But then your liability is just like a collector under section 18.
Yes, ma'am.
That whenever the government withdraws from such acquisition, the collector shall determine the amount of compensation due for the damages suffered by the owner in consequence of the notice or any proceedings thereunder, and shall pay an amount to the person interested together with cost.
Yes, ma'am. This land acquisition matter, your lordship must have come across a few cases. I am appearing in some cases against the state of Arunachal Pradesh. There, my lord, difficulty arises from many angles. One is there is an old act. The second is there is a new act. My lord, notification is issued under the new act. While determining compensation, in order to avoid all the complications, they determine the compensation under the new act. Notification is under the old act. Then there is another act of Balipara Satya of 1947 regulation, my lord, which do not provide for this detailed procedure of determination of compensation, award, etc. It says there is a reasonable amount of compensation is to be paid. Now, in the border areas, what is happening, my lord? The collector proceeds and compensation is determined just before the time comes for payment. They say that there is no award. So these problems are coming up. Here, my submission should be twofold at this stage, my lord. First of all, if at all, ultimately, after hearing the matter, if the lordships are of the view that compensation has to be paid, then since it is the central government is not a party, possibly central government will have to be heard. Then I am told, my lord, central government is not a party at all.
It's not a party.
Fine. Because collector is acting on behalf of the appropriate government everywhere. And there is a judgment, if your lordships are well aware, my lord. Everywhere notice, hearing, etc. Interested person, the expression is interested person. The authority for which the land is acquired is also an interested person.
Yes, section 50 of the old act is very clear.
Very clear.
There is a judgment of the Supreme Court in case of Himalaya tiles. It is also
1987, I have brought that matter.
Himalaya tile.
I have brought it, man.
I'm
Your lordship is aware of that.
I'm aware about it.
Himalayan has made it very clear that the authority for which the land
So,
is
as
being
soon as
acquired.
you refer to this, I could recollect Himalaya tile.
So that being the position where first of all possibly they should make it.
It is AIR 1985.
87, man.
87.
87. AIR 1987,
87.
Supreme Court page 1118. Here. It is reported in SCC also.
Yes, it is reported in many.
Famous judgment. Lordship. Fallen from your lordship.
Therefore, we will have to.
My lord. Lordship will take two aspects. My lord. First, my lord,
No, if your officer, because he also may not be there when this
my
has
lord,
occurred.
my lord, exactly.
He will have to find out the old files from his office.
My lord, my lord,
Then we'll be able to do something.
Exactly. Two things are required to be done. Now, the aspect which your lordship is indicating, but that I'll see. And secondly, possibly central government, at least at this stage, let the central government come.
Yeah, let us first travel whether 48 power is rightly exercised or it is abandoned.
All right. Lordship will give me some time. I'll examine the matter.
Now, do you have, officer, any idea? Any of the lands declaration was issued
Declare.
for any plot of land which was part of section 4 notification? For none of the plot? Then it is abandoned.
Why should even the central government pay, my lord? And it will be huge amount of money, 2,000 bigas.
That is what when I went through the record, I was little taken aback. In all these insistences for that.
My lord. And after it's a public money.
Yes.
It's our money.
So now that you are there, all three of them, and you please call for the original file and let us
I'll
look at it.
I'll look into it. I've understood.
It is not just we could have disposed of the matter by saying that the collector may look into it, but then we may be doing injustice to the government.
Yes.
And if they are entitled to, you also take the assistance on this. That if it is abandoned under section 6, because now there is no question of any declaration under.
No.
Then whether 48(1) would be attracted or you can just say abandoned.
Yes.
Because you have done nothing.
Nothing, absolutely nothing. Because they ultimately said that we do not require. So EC did not proceed.
Because EC is a special land acquisition officer.
Yes.
Next week.
My
Or Mr. R. Mr. R. K. Bora and for the state and he is for the petition. He is the filter at the is for the earlier order. Mr. Majmudar and additional advocate look into the original record and report back about the correct factual situation as regards the aspect when the at what stage the land acquisition proceedings were stopped to enable him to do so. Attempt to 7.
Let it be on 19th panel. In the meantime, I get some time because they are from filter manual. They have to
19.
Deep.
No.